All right, welcome to what I certainly hope is going to be a thrilling webinar on the new California Consumer Privacy Act. Goal of today is to get you guys pointed in a good direction on dealing with CCPA. Ideally, we're going to simplify that process for you. So it's always helpful, I think, to know a little bit about the person who's speaking. Certainly shapes their perspective. Mine is the fact that if misery loves company, I'm in the same boat with you. I'm fighting the same battles as you are. I'm the CISO of Pivot Point Security. I act as the vCISO of a law firm. I act as the virtual CISO for a registered investment advisor. In all three of those cases, I'm dealing with a lot of personal information that needs to be protected well, right? Needs to be in conformance with laws like CCPA, GDPR, etc. I also serve as the Solutions Director of Pivot Point Security, and really what I'm doing there is building out and shaping the service offerings that we have, including those that are around privacy. So, one of the ones that I particularly like is, ISO 27701, which is a great extension to the ISO 27000 family, which is a great mechanism for dealing with privacy. So how did we get here today, right? So I think the big problem is folks like Facebook, as an example, our private information has been extensively monetized. You could use the term abused. And really what happened was people started to get a little upset. You look at what happened with the election. You look at people's personal information being sold in ways that we really never intended for it to be. Really what happened is people got upset. The government stepped in and decided that there's a way to approach this. The original solution to this problem, and I use the solution very loosely, was something called GDPR, the General Data Protection Regulation, which was in the EU a couple years ago. And now we have our own, I'll call it homegrown version of it called the California Consumer Privacy Act. CCPA is intended to give people control or help people control their personal information. And really what it says is that you as an organization are responsible to tell people what data you're gathering, disclose to them, where it comes from, what you're doing with it, and give them the right to control your use of their information. So anytime you talk about privacy, there are a couple of key things terms you need to be aware of. So the first is something called a data subject access request, commonly referred to as a DSAR. That is that when a person requests the information that you have on them or wants to take action on that information, that's called a data subject access request. And they act on their personal information, and the law covers their personal information or private information. You use both terms interchangeably. And what's important is that the law, CCPA changed the description of what personal information is very, very significantly from what we've traditionally thought of as being personal information or personally identifiable information, another term you hear, because that was based on what are referred to as breach notification laws, starting with California SB 314, Mass 201. You're probably familiar with some of these laws and regulations. And where it's very, very different is that virtually any piece of information, and that's the term they use actually in the standard, that is reasonably capable of being associated with or could reasonably be linked directly or indirectly with a particular consumer or household is personal information. So that's your dog's name, that is your street address, that might be your zip +4, that might be your IP address, your email address, sexual orientation, you name it, pretty much anything now is considered personal information. And that's really, really significant because it changes the way, you probably already are doing a good job of handling what we used to call personal information or PII, Social Security numbers or driver's license numbers, checking account numbers. Right now, that same level of protection or even a greater level of protection is for any of the information that you have. That's one of the main reasons that it's different. The second one is that while we've had GDPR in existence for a couple of years now, it was originally something that a lot of our clients in the U.S., the small to medium-sized businesses, SMEs, wanted to take action on. And then when they realized that, well, I don't think an Eastern European data protection agency really has any jurisdiction or is likely to enforce this law on us, most people said, we'll wait for something new to come along. Well, this is that. So this is something new that has the potential, according to the IAPP, of affecting about 500,000 businesses in the U.S., a lot of them small to medium-sized enterprises. So how do you know if CCPA applies to you? The first test is, do you exceed 25 million in revenue? If you do, it applies. If you have more than 50,000 California consumers' private information, it applies. If you sell information and more than 50% of your revenue comes from selling private information, it applies to you. So a few of you are probably like, whew, dodged a bullet. There is one other way that I think that it applies to people that we're seeing is that's the last box I added called contractual obligation. So it is entirely possible that while you may not meet one of those first three criteria, that you may have a customer who shares information with you, and in order for them to comply with the law, they're going to ask you to comply with the law. We've already seen this, what we refer to as a flow down, often extended through a document called the Data Protection Agreement. So what is it about CCPA which is so significant in terms of the rights that it grants? So first and foremost, right, is the right of disclosure. So you need to tell me what information you're gathering, and you need to tell me what you're doing with that information at an explicit level. Second thing is that I have the right to control how you use my data, whether or not you can market to me, whether or not you can use that to market to somebody else, whether or not you can sell that information to a third party. Third is that right to opt out, right, that you can't sell that data to an individual with another entity without them explicitly allowing you to do that, right? So that if I change my mind and say, yep, I don't want you to sell my data anymore, I have that right to opt out. And I think the most challenging one is what we refer to as the right of deletion. That is that if I call you up and say, hey, I no longer want you to have any of my personal information, that at that point you have an obligation to delete or get rid of all that information, which in most organizations, as you might imagine, with the way that data has this tendency to grow exponentially, is a very, very challenging issue to deal with. One of the hardest issues about CCPA. As far as us, why am I sitting here talking to you about this? This is what we do. This is what we've done every day, all day for the last 20 years. We help people become secure and compliant. Privacy has always been part of the equation. With GDPR and CCPA, privacy really has crossed over. It used to be, I would say, a separate discipline, if you will, from information security. I think at this point, information security, privacy are sort of hand in hand. And I don't, it's sort of, who got privacy on my security or security on my privacy? The old Reese's Peanut Butter Cups concept. I think at this point they're indistinguishable. I don't think you're going to be able to be an information security professional and not be a privacy professional if you look forward a few years. So if you're looking at this and going, yep, we're going to have to do something, but where do we start? You're welcome. Right? So this is our proven process for doing this. We've worked through, same thing with GDPR compliance, by the way. We've done this with many organizations. And if you want, you are welcome to steal and use it. So I'll give you a second more to absorb that, and then I'm going to walk through each phase independently anyway. So this is the bear, right? And this is, it is a requirement of the frameworks to generate what we call a data map. In GDPR, I think it's called Article 30 processing activities, something like that. And so let me explain what a data map is. So if you think about it, you get information, private information, from somebody or from a third party about other people. That comes to you. So how does that data come to you, right? Then what are the processing activities, once you have that data, right? What are the processing activities that act on that data within your organization? You can think of processing activities by thinking about what are the different departments or business units of your organization. So human resources, accounting, think about information technology, marketing, right? So what is the information that they're getting, and what are the processing activities that act on it? So when I say a processing activity, what do I mean? So the easiest one to think about is human resources. So they have a processing activity we might call employee recruitment, right? So what happens in employment recruitment? So you place a job ad and then somebody sends you a resume. Well, how does that resume get to you? Right? Is that coming in through Indeed? Is somebody going to your website and uploading that to your website? Are you getting that through recruiting organizations? Are you going out and gathering that information directly off of LinkedIn? Right? Because you can do a direct recruitment of an individual. So what happens during that recruiting process? And then not only did you get that information, right? What data elements are included? So when you think about a resume, there are a lot of data elements that we have to break it down into. It's not just a resume. It's a resume that incorporates an email address, a first name, a last name, an address. It might incorporate their educational background, their certifications they have. It might give you reason to know information about their personal likes and activities and involvement in religious and political organizations. All of those are technically data elements. They're personal information. So all right, for this recruiting process, we get resumes. Resumes have these 20 different data elements, we call them, of personal information. And now, what happens to that data? So if you think about it, that data might, let's say, go into an applicant tracking system, that's housed by a third party. When your HR person says, oh, this is a good person to interview, what do? Do they pull the data out of the HR tracking system and send a PDF or a Word doc to the recruiting manager? So they can do an interview. What do they do with it? Do they share it with other people on their team that are going to be part of that interview process? Are you doing credential background checks prior to that? Are you doing employee screening? Right? Let's say, are you doing critical thinking skills, or are you doing personality profiling? Right? Third parties, right? So what's happening is that all of these data elements are mapped to these processing activities, which are mapped to the assets that support those data processing activities. The databases, the applications, the networks, the email systems, the SharePoint infrastructure, wherever all this data is ending up. That sounds like a lot of work, and it is. And you say, well, that sounds crazy. Well, if you think about it, how are you going to, if you don't know all that information, how could you ever service a DSAR? How could you ever say, here's all the information we have on you? Or how could we say, yep, we're going to mark that not for being sold? Or how can I say, hey, don't worry about it, we deleted all the information that we had? So data mapping is absolutely far and away the most important and significant part of dealing with a privacy standard like CCPA. Once we have those maps, so we understand the controls and we understand the processes, the next thing we can do is say, okay, based on what we've learned, where are our gaps that have the potential of that we need to think about closing? So if, as an example, if you're sending that information outbound to somebody, let's say after your employee's onboarding, we have a processing activity around getting them to ADP for payroll. If we're sending their information, their what do they call that? W-2 form, not W-2, W-9, I think, that you fill out, or I-9, whatever it is part of that process. If you're sending that, let's say, to this third party and it's not encrypted, oh, we've got a gap in what would be a good control, right? That data needs to be protected in transit. If you've got a third party that hasn't gone through a vendor risk management process, right? You haven't issued a security questionnaire. You haven't asked them questions about, haven't obligated them to treat that data in accordance with privacy laws, right? That's a gap. So what we'll do is we'll work through gaps, right? Do you have a policy on your website, a privacy policy? Does the privacy policy cover cookies and things of that nature, right? That might be another gap we're going to identify. So the idea here is that we're going to identify, look at the maturity of all the controls in your environment that are going to help and be important from a privacy perspective and a security perspective, for that matter, because security, you can't have privacy without security, and make sure that we understand where you are and what you need to do to get to what we would call the target state, right, which is being able to be compliant with CCPA. So you have also probably heard the term a data privacy impact assessment or data privacy impact analysis. So a DPIA, which is commonly shortened to, is something which is, now that we have an understanding of that data and we have an understanding of the gaps, we need to kind of look at where are the critical risks that we need to be aware of, right? Where are the risks to personal information in our environment? And do we need to analyze those risks in a consistent, repeatable way, so that way we can determine which of those risks are reasonable and appropriate and are acceptable to us at this point, and which of those risks are something which needs additional risk treatment. So as an example, if we determine that we do not do any vendor risk management for any of the clients that we're sharing tons of personal information with, that would be a risk that we would want to actually address. And we address those risks through something called a gap or risk treatment plan, or gap remediation plan, risk remediation plan. You hear all these terms, they all mean largely the same things, right? So you can also think of that as an action plan. Now that we know what controls do we or don't we have in our environment that we need to have, where are the critical risks that we need to close, right? Now we have an action plan to move from where we are to our target state, which is full CCPA and or GDPR conformance. So, as you might imagine, in some organizations that can be a lot of work. And these are the areas that I see as being the biggest challenges for most organizations, right? So you've heard me talk extensively about third-party risk management. Why? You're going to be shocked at how much you share personal information with third parties. And you have obligations under these laws to make sure that you are doing so in a way that they understand what their obligations are. That if there's an incident there, they're going to reply. That you're going to inform you so that you can follow through your incident response plan. You need to make sure that they agree not to sell you. If you give them the data, they agree not to sell the data. All that kind of fun stuff. So, third-party risk management is a big part of dealing with this law and regulation. Implementing reasonable security. So the law uses the term reasonable security. So you can't have privacy without security. And what is reasonable security? Unfortunately, the law doesn't define that. So the best we can do is, if you look at the California AG in 2016, in another law, he cited CISCSC, the Center for Internet Security, Critical Security Controls, or equivalent, as an example of reasonable security. And the reason why it's important that you know that you're achieving that mark at the same time you're achieving, compliance with the specific data privacy provisions around processing a DSAR, is that if you meet the requirement for reasonable security and you had some type of a breach, you certainly are going to be protected from being proclaimed as negligent, which falls into a very significant data fine category. So you're going to want to make sure that your information security is where it needs to be at the same time you're working through privacy. Third thing is that be aware that you may want to change some of the processes that you use to minimize PI sprawl. That's an important part of that. We do that during that scoping, during the data mapping process, are there ways to change the processes to make this easier? So for an example, we had a client that in their marketing department, they were send out tens of thousands of holiday cards each year. And the way that they did that was a law firm, and they have, 200-300 partners in the law firm. What they would do is they would send that same list of 20 or 30,000 names to every one of the 200 to 300 partners and say, hey, just checking in, please take a look at this list and let us know if it's acceptable or anyone needs to be added or removed. Well, partners in law firms are busy people, so what they do, they don't actually do the work, they send it to somebody else to do it. So now what we've gone from is having one copy of this Excel spreadsheet to 200, now forwarded to 200 more people, and so on and so on. And we've gone from talking about a data explosion, right? We've now 500 copies of this data that we need to account for if somebody says, hey, delete my name, delete my address from your records. So what we did there was we said, guys, this is crazy, right? This doesn't make any sense. Why don't we just put this data in a database, and then we'll have everybody go to the database and review it there. And really what we're able to do is go from a very, very complex issue to solve to a very, very easy issue to solve if we had a DSAR subject to any of that information. Last, and I said it last, but it's probably the first thing you should do if you haven't already done it, is make sure that you've got a privacy policy published on your website. The reason that's so important is, I do a lot of work in law firms, and there are well-known entities that go around, and when new laws and regs come out, I think they call them plaintiffs' attorneys, what they do is they look for the potential class action lawsuits, or they look to attack companies that are not doing the right thing. And if you do not have a privacy policy on your website, it is very easy to know that you're not CCPA compliant, right? Because you have to have explicit communication of what you're doing with the data, and it starts at your website, because what are you doing with my IP address? What are you doing with the cookies that you're putting on my machine? So if you haven't done this already, pause this, I'll wait, and go get a legal policy, get those legal policies, the privacy policy and the cookie policy on your website. That's really important, okay? So I've given you a lot of bad news. Don't shoot the messenger. But I do have some good news. The good news is that if you become CCPA conformant, you are going to be conformant with GDPR. They're largely the same, slight subtle differences, but addressing one largely addresses the other with a few minor tweaks. So I think that's really important, and at least it's a little bit of good news. So why is this important? Well, because if you don't address CCPA, you could end up in some legal hot water. Should the California Attorney General bring action against you, the standard fine, if you've done everything pretty right, is $2,500 per resident. You heard me mention that if you're not, let's say as an example, reasonable and appropriately secure, that could rise to $7,500 per name. So that could have a pretty significant impact on a lot of firms. I don't know why PowerPoint chose not to show the rest of that image. Maybe we didn't pay the usage rights. Maybe it's personal information. Maybe the shirt he was wearing is personal information. That's right. We actually intentionally redacted that part of the image. The good news is that I kind of laid out a plan for you to actually get to where you need to get to. If you get there, the nice thing is you did reduce that legal risk, right? And you reduce the risk that you're going to end up in a situation with the California Attorney General. The second thing that you've done is that by going through the privacy information, you're going to address security at the same time. So what we've done is we've further reduced your information security risk, which is always a good thing. Last is that if you follow this process, it will set you up for future privacy regulations or other privacy regulations. Just for the record, APAC, Brazil, Mexico already have standards. NIST just put out a new framework for the United States that may or may not become a national standard. There is a bill proposed for a national standard on privacy. Many other states have privacy standards brewing. Believe it or not, you probably want a federal standard. That's at least what the major technology companies in our country want. They actually went to Congress and lobbied for one. Why? Because they don't want to have to deal with 50 of them. If any of you guys deal with the breach notification laws, right? We have 50 different states that have breach notification laws. It started with California SB 314 and Mass 201 is one a lot of people know offhand. We don't want to be in that situation again. So it might actually be good news to have a national standard for privacy, which sounds a little bit unusual, but it really isn't. So Jeremy, do we have? Okay, cool. Can I just answer all of this with one answer, Jared? Just it depends. No, yeah, I was afraid of that. So the answer is it depends. But to be a little bit more helpful, let me kind of give you some guidance here, or give you some estimates. So how long does it take to comply with the CCPA? Obviously, depending on how big you are, how many different business units, how many different locations that we need to deal with, it can vary quite a bit. For most of the people listening to this, let's say that you're somewhere between 50 people and 500 people. Let's say you're located in one or more locations, but most of your business processes are centralized. Let's say you got 5 or 6 departments that we have to work through data mapping, for processing activities. Probably getting through the first phase of the project, understanding the scope, understanding the generating the data maps, getting through data privacy impact assessment, control maturity assessment, and leaving you with a risk assessment. Well, data privacy impact assessment is your risk assessment. It's just a personal information focused risk assessment. And then getting you to that action plan, right? The risk treatment plan or gap remediation plan, however you prefer to call it. That's probably 2 to 4 months in most organizations. And then how long does it take to clean that stuff up? Again, that depends on how much there is to do. How much, do we have a lot of information security things to clean up? Do we have to do third-party risk management on 10 firms or 10 vendors or 100 vendors? But I would say with most of our clients, we've seen that take somewhere between an additional 3 months to 6 months. So I think with an average client, we're probably seeing something between 5 months would be short, 10 to 12 months would be long. Cost, again, huge, it depends. Those data mapping activities really are what drives the cost. So, where, let's say for a standard organization, it might cost be unlikely if you use a consultant like us, it would cost less than 30 grand, probably be unlikely it costs more than 60 grand for most firms. We did have a client recently where we started with where they were a restaurant chain. I'll use that term, it's not exactly, but I'll use that term. And they had corporate functions, but then what happened was they had an HR and a marketing function and a specific catering function at each of the individual properties. So what we had to do is we did the data mapping centrally, and that fit into that price point that we talked about. Then we had to go to dozens of other locations to meet with and understand, like, how did they handle personal information? So when a catering call comes in, where does that information go? When they're getting reservations for dinner, whether they come through Open Table, whether they come through Resi, Yelp, what do they do with that data? Call-ins, they're writing it in a book. Okay, well, how do we keep track of the information that we wrote in a book that's got personal information? If somebody says, forget the fact that I dined with you on this particular night. So that's where the price can escalate depending upon the type of organization that you are. And then last, any specific tools, and if so, do you recommend any? Do you need any specific tools? No, absolutely not. In fact, I think most of the times that we've done CCPA or GDPR or even 27701 with clients, we're doing it with Excel. It's a great tool. It works super well for data mapping. Because really what we just need to do is keep track of what elements map to what processing activities to what storage locations, basically, and tools and assets that support them. So yeah, you can absolutely use just basic tools of that nature. Of course, you're going to layer them on top of some good tools for doing, SharePoint or Teams or Slack or something of that nature for communication and version control and documentation. So make sure we have good control over that. If you have a more complex environment, let's say you're one of those organizations that's got dozens and dozens of locations, and each of those locations need to have some data mapping done at them. There are some great tools out there that will simplify that process. So something like OneTrust is a great tool, very well-known tool. Because what they can do there is you can actually do the data mapping rather than via interviews. You can do it via what we call web-based surveys. That's both good news and bad news. The good news is that you can get it done much quicker at a much lower cost. Bad news is web-based surveys tend not to end up with nearly as accurate data because many of the people that are filling out the forms don't really understand the questions. So beware there. Your mileage may vary, but that's a much less expensive way to do it if you have a broad grouping. Second thing where there's an advantage to doing it with a tool of that nature is that if you are, especially if you're dealing with GDPR, generating some of the maps becomes kind of elegant because it's built right into the tool. It's got all these tools built in to generate an Article 30 report. Click here, boom, you got an Article 30 conforming report. Also, if you have a lot of vendors that you need to do vendor risk management on, it incorporates a module for doing vendor risk management. So you can just tag a vendor in your data map to needing vendor risk management, and it'll trigger a process to actually, let's say, solicit that information, like issue a security questionnaire and initiate that process in your system automatically. It also does some cool things with if you really want to get fully automated, if you're going to subject a lot of what we call DSARs. You can actually, they give you the tools to plug a DSAR module onto your website. So that makes it easy that someone goes to your website and says, I want to know what information you have on me. It'll literally flow right into the OneTrust tool and make it simple for you to actually service that request, right? Present the data directly back to them right out of the tool, which is really elegant if you're going to service a lot of those. So I think there's pros and cons to the tools. They add some expense, they add some complexity on one side, they eliminate some complexity and simplify things if you have a complex environment. Jeremy, anything else? Cool. Then that means I did my job. So hopefully I've simplified it a bit for you. If you have any questions, please don't hesitate to reach out. We're happy to chat, happy to be helpful. Send you some Excel-based templates or something of that nature to help you do your data mapping. Please let us know how we can be helpful. Thanks. Have a good day.